They called him a bad doctor. They said he committed sexual assault on his patients, but now a judge has determined that he's permitted to return to practice. I'm talking about one of my clients, Dr. Sanjeev Kumar. Now, in healthcare fraud cases, we often see the government do a full court press on preventing a physician from practicing while they're facing allegations. And of course, all of you know that in this country, people enjoy the presumption of innocence. You are innocent until a jury determines that you are guilty, and only then can you be punished. Pretrial restraint is not meant to be a punishment, but oftentimes attorneys or even defendants will agree to not practice, fearing this sort of government interaction and maybe additional charges. And that's usually a bad move, and I will tell you exactly why. First, if a physician isn't practicing, they're not doing what they love. That spiritual issue has a huge impact for somebody who's facing allegations against the federal government. It's often best for them. And the outcomes are much better if they continue doing what they love and they continue their practice. But there's another reason, and that is a financial reason. It's a very expensive proposition to face the federal government at trial. And if you don't have the ability to continue to practice and continue to see your patients, not only are they harmed, but also you're not able to get income from what you love to do and seeing those patients in order to pay those costs. But a third and very important reason, like I just mentioned, are the patients themselves. The government doesn't get to say who a patient can go to. And if there are patients who clearly believe that this physician is somebody that they should see, they should be able to continue to see that person, even despite the allegations. Oftentimes, these healthcare fraud allegations are related to several complaints about a provider, but not related to the entire practice, and patients should not have their choice taken away from them by a court. So we elected to litigate this issue on behalf of Dr. Kumar, and as a result, just yesterday in Memphis, Tennessee, a judge ruled unequivocally that he should be able to return back to practice. There were some restrictions placed on that return back to practice in order to ensure that the government's concerns were somewhat alleviated, but he is able to return to practice and do what he loves doing, and that is taking care of his patients and making sure that their healthcare needs are absolutely met. It's a wonderful result. I just want to go a little bit into these bond hearings so that those watching who don't know too much about this can really understand what's necessary. So, of course, federal cases, as you all know, start with an indictment. That indictment is often handed down by a grand jury. They vote and they say there's probable cause to believe that somebody has committed a crime. After that, that person goes before a magistrate judge and there's something called a detention hearing. At a detention hearing, there's the question whether or not the defendant should be detained pending trial or if they should be released. And if they are released, what are the circumstances of release? What conditions can we place on them to determine whether or not they can be safe in the community and to ensure that they will be able to return for court? Often with physician cases, healthcare fraud cases, we see two conditions. First, that you not practice. Second, that you not bill any health insurance company. Both of those are normally a bad idea for a physician to agree to, and often we litigate this. If we decide to litigate it, we take it to a hearing. At that hearing, the rules of evidence don't apply, but we have the ability to put on witnesses and introduce exhibits. In this particular case, we introduced about 23 exhibits. We called two witnesses, both high-impact witnesses that were able to describe this practice, how it operated. One of them was a state medical board witness who discussed an investigation that they'd gone into where they determined that there was insufficient evidence to substantiate the government's complaint. That has a powerful impact early on in the case. The magistrate will make a decision, and then that decision can be appealed up to the federal district court judge. And the federal district court judge makes a determination, often based on the evidence that happens at that hearing. Can you appeal? Certainly. If you lose that detention hearing, federal judge doesn't agree with you, you have the ability to go to your federal circuit court of appeals and appeal it. I was involved in one case, United States versus Bothra, that resulted in an acquittal. Dr. Bothra was detained for a long period despite quite a few appeals. And I think he went before the Sixth Circuit Court of Appeals perhaps 6 times, maybe even more, to appeal his detention decision. Detention is inappropriate in non-violent cases, even when the allegations are trumped up to sound like something else. Healthcare fraud, white-collar cases, non-violent cases, there are restraints you can put on somebody to make sure that there aren't going to be any dangerous issues in the community. We believe that wholeheartedly. And in Dr. Sanjeev Kumar's case, we were happy to walk away from Memphis with a victory on this issue and allow a good doctor to return back to the practice as he should while he awaits his constitutional right to a jury trial and to get the truth out. I'm Federal Defense Attorney Ron Chapman. If you have any questions, drop them down in the chat. Email me, call me, send me a message, whatever you have to do. I'm happy to answer your legal questions. Thank you.